So with this whole issue with the Attorney General's office now, and is the Attorney General Baron HERMER actually allowed to be a member of the House of Lords? So there is one possibility for the interpretation of Standing Order 87, which says the Attorney General may take part in deliberations of various committees for the House of Commons, being a member of the House. It could be interpreted that you could argue that he doesn't have to be a member of the House of Commons, but if he isn't, then he isn't allowed to take part in deliberations in committees, right? Or any other proceedings. But if that's the case, then what's the point in having an Attorney General who does not take part in deliberations in committees for the Commons? What's the point in having an Attorney General? Because you want to have your Attorney General present, right? Now, if you say, well, he doesn't have to be a member of the House, but if he's not, he can't take part in any deliberations, right? Then he's only a member of the House of Lords. But get this clear, right? Historically, through all England, all the way up to 2005, right, the House of Lords, when it comes to acts and bills being put through, right, when it comes to laws being made and progressing through government, right, the law lords were the ones who scrutinised legislation on behalf of the House of Lords, because they're all legal experts, right? They don't need an Attorney General to give them deliberations and advice in the House of Lords, right? Because legislation gets checked by the House of Commons, in the House of Commons, on behalf of the Commons and deliberated on, and then the Lords don't participate in that. And then when it gets passed over to the House of Lords, then the Lords check legislation on their half, right? You don't have, like, members of the Lords going into the Commons and Commons going into the Lords when it comes to putting laws through, right? They're separate. So you didn't need an Attorney General in the House of Lords. Now, after 2005 Constitutional Reform Act, you don't have members of the law lords are only taking part in, like, the Supreme Court, and they're the senior judges, right? They don't participate in voting in Parliament, really, or committees. In the Constitutional Reform Act, the Chief Justice can make representations to Parliament which concern the judiciary, right? And anything to do with the judiciary, they can make representations to Parliament, the Chief Justice, right? But also the Chief Justice and President of the Supreme Court can contribute towards... They can make written representations to committees, but it only says the President of the Supreme Court and the Chief Justice, right? So that, to me, would mean they're allowed to take part in those deliberations like they have in the House of Lords instead of an Attorney General. But no, it doesn't say any other judges can, right? Now, that, to me, would mean that Brian Leveson wouldn't be able to, and he gave lots of evidence and submissions to committees, right? It says the President of the Supreme Court can and the Chief Justice, but it only says they can. So I don't think Brian Leveson's submissions were ever lawful, and he's definitely not independent now because he's leading Investigatory Powers Department, right? So how is he independent when he's working with and assisting the police and CPS in prosecutions? So how can he be impartial when it comes to getting rid of juries, right? Well, that's a different matter. So going back to the House of Parliament, right? The houses of Parliament, right? Now, one of the main functions of the Attorney General historically is for cases that concern Parliament. And they had proceedings in Parliament, right? So he needs to be there. But when he's in the Lords, all through history, we don't have Attorney Generals who are peers, right? They're all members of the House of Commons and elected, right? As far back as we can find information on. They're all elected. It's an elected position. And only Geoffrey Palmer was made a Lord, and that was because of the Civil War and the Restoration and a special, he was going after prosecuting members of the peerage, and it was like a one-off thing. But he still was elected. Actually, he still did get elected right into the Commons, and then it went back to normal like after there ever since, which is like decades and decades and decades and decades. So this issue is particular to Tony Blair, Gordon Brown and Keir Starmer, right? And it doesn't actually affect the Tories. The Tories haven't broken this law, but they stood back and let Labour do it without intervening, right? So they failed to act. So it's only like Tony Blair, Gordon Brown and Starmer, right? So it's particular to the Labour Party and particular to this kind of like sort of, well, we'll call it this kind of like, it's definitely something to do with this sort of like, World Health Organization, World Economic Forum, Fabian, Blairite, cult type thing that's going on, right? Now, this is the thing, right? So, legal proceedings in Parliament. Well, legal proceedings in Parliament, you only had a case heard in the Lords by appeal if you appealed your way all up the courts, right? But then it got to the House of Lords. Now, that is appealite jurisdiction. Now, they scrapped that jurisdiction, right? And said they've replaced it with the Supreme Court, okay? That's what the 2005 Reform Act did, and they withdrew the Appealite Jurisdiction Act, right? But that's if you already have a case that started low down, right? Either against you or that you started, right? Whether it's civil or criminal. Now, this is the thing. The House of Commons, the Lords and Parliament have their own proceedings, right? They have their own usage, the usage of Parliament, right? Democratic cases, casework with MPs, petitions, committees calling for evidence from the public, all these type of things, right? Now, you can be in contempt of Parliament, right? Just like you can be in contempt of the courts. Now, the Attorney General's office is meant to deal with contempt cases, right? But we're taking it as contempt of the courts. Now, this is the thing. You can have contempt of Parliament, but the thing is with contempt of Parliament, it says that only Parliament can hear contempt cases of Parliament and no one else, right? Because it is the privilege of Parliament to hear their own affairs and matters, right? But we aren't having any cases. Apparently, the Department of Culture, Media and Sport has some processes in place currently for hearing contempts, right? But that's the only department that does. They're all meant to, but because no one hardly does petitions anymore in paper, and they've got them all to e-petitions, and they're heavily restricting them and trying to limit them to amending and strengthening the law petitions, right? And they've got the Parliamentary Commissioner for Standards, the House of Commons Commissioner for Standards for complaints against MPs, right? And they've got the Parliamentary Ombudsman dealing with complaints against government departments itself. They're trying to get rid of all and any legal proceedings in the House of Commons or the House of Lords. They're trying to get rid of all contempt and other associated proceedings, right, except committees. And they've talked about this in the Privilege Committee reports. So that means that you hardly have an Attorney General in Parliament for public business, right? Maybe rarely for private bills, but who's going to prosecute you for doing a private bill, right? You put private bills in the newspaper, right? You're meant to put private bills in the newspaper so people know about it, right? You might get someone who's going to prosecute you for putting a private bill in the newspaper, right? That's why you got the Parliamentary Papers Act and protections and all kinds of stuff, right? They've pretty much, right, got rid of having the point of an Attorney General for proceedings in Parliament for either house, right? So he's hardly any use. He's like a spare prick in a brothel, right? And it's a joke, but it's a serious joke, right? So if there's no point having the Attorney General in Parliament hardly anymore for legal proceedings, he's only doing legal proceedings in his office for general dog's body government stuff, right? Like, contempt of the courts. Or you can contact him for contempt of the courts, or if you want a review of an order or sentence, the public can have it reviewed and so forth. And various different government departments needing the Attorney General, like you have local council legal services or whatever, right? Okay, although most government departments have got their own prosecutors, right? Like, Customs and Revenue or used to have their own prosecutors. Royal Mail used to have their own prosecutors, right? Like postmaster type area stuff, right? So why would you have an Attorney General in Parliament? Now, this is the thing. You had an Attorney General in the House of Commons, if he's a member of the Commons, to take part in deliberations on committees. He can't vote or move, but he can contribute, he can deliberate, right? He can affect, right? Now, surely he may not do that, according to standing orders, if he isn't a member of the House, right? But what's the point in having him as the Attorney General? Just because, we want, because in the Lords, you don't have that function because the Attorney General was only there for an assistant in legal proceedings, right? Which they don't have hardly anymore. The Law Lords are meant to be the ones who deliberate on matters of legislation in the Lords, right? But they got rid of most of the functions of the Law Lords in the Lords, except the President of the Supreme Court and the Chief Justice may submit things, right? But also the Chief Justice can to either house concerning the judiciary. But when it comes to legislation and bills going through Parliament, that's not of concern to the judiciary of itself, right? But the Chief Justice and President of the Supreme Court can actually give input when it comes to bills and legislation coming through, as far as I can ascertain. If I'm wrong about that, right, you can, I'll put my hands up, whatever, right, this is from my opinion and my assessment, right? So, if you're having... if you want to, why would Tony Blair, Gordon Brown and Keir Starmer not want their Attorney General to be in the House of Commons? Right? Maybe because they want to try and get rid of him out of there or not have one in there, right? But that would be, what's the point? Wouldn't you want or need one in there, right? Now, the thing is, you could want a peer to be Attorney General just because, you might, because of his expertise, or you specifically want this exact person that you've chosen to do it, or the prestige of it, right? But let's get this clear. The whole time since 1948, they've been diminishing the powers of peers and their peer privilege and other privileges of peers. They've been diminishing them and reducing them, right? They don't really want peers to have peer privilege anymore as much as they can. So as for prestige or not, what's the point for legal purposes, right? This is almost like why I have Geoffrey Palmer in the Restoration, right? What's the point in making him a peer, right? Now, if you're just doing it for the name and the prestige and style of it, right? Fair enough. But this is the thing, right? All Attorney Generals in the past, even Geoffrey Palmer, were elected by the public. They were chosen by the public to be in Parliament. So it's an elected position, and then obviously they don't appoint them as Attorney General, but they chose them to be in Parliament. It's an elected position, right? Elected person to be put in position, right? So, but now they're not. Starmer's just picked him out of the ether. He just plucked him, right? I can have anyone. I can't choose from these people that the public elected, right? Starmer's just picked anyone, pick a needle in a haystack, right? I want Baron Hermer to do the job, right? I want Hermer to do the job, right? Out of all England, but the people didn't elect him, right? But I chose him. Now this is the thing, right? If he's going to do that, but then there's hardly any point in having him in Parliament, in either house, right? Then he's having the Attorney General in his office outside of Parliament just for general government business, and he's saying, I get to choose who he is, because of his expertise or whatever. But he's still meant to be elected. He's still meant to be chosen from a pool of elected people that the public chose, right, for that position. But this is the thing. Notice that The House of Commons is an elected body, elected by the people for the people. And when you petition Parliament and have cases in front of Parliament, it gets signed by your MP who's elected, and there's certain judicial functions of the House, right? Which is a judicial functions of Parliament. But more and more and more, they've been doing like these Ombudsman Acts, right? When an MP signs it off, but then they let someone else sort it out. So Millbank Tower, an entire building of non-elected people led by someone who's got a CBE appointed by the King, but they were never elected by the people, right? To deal with all the complaints about government departments, right? But we're not getting the privilege of bringing the case. And if they don't take it on, apparently they're trying to make out it's not privileged. And the same with the House of Commons Commissioner for Standards. Apparently, if he doesn't take the case on, apparently it's not privileged. So how did you manage to get the evidence in the first place to put the case together, to try it, when they don't give you the privilege? The privilege is in the law of the observation of due process of law 1368 and the Bill of Rights. It is given to us, right, after 1688. That's why you don't need a writ from anyone else, right? You take up the law yourself. The legislation gives you the power, right? And they're trying to make out that if he doesn't take it on, you haven't got any power, right? But if he took it on and it was privileged and, oh, now he's taking it on, now that he says so, right? You're going back to the model of writs, right? Because before 1688, if they didn't accept your petition, or if they didn't recognise it, or if you were getting prosecuted in the courts and you needed help, right, you would go to your MP and he could write you a writ of privilege to enforce your privilege, which you get from doing what your usage, right, from usage of process, right? And you could get lords to write writs of privilege, and you could get bishops to write writs of privilege, or the speaker, right? They scrapped it. Persons in Parliament or in government writing writs to acknowledge and support your usage was abolished, because it was given to you by law, so you can make the representation yourself, right? But now they're saying that, oh no, unless the House of Commons Commissioner for Standards takes it on, you haven't got it. So it's like he says whether you have it or not the law. But they abolished whether the MPs or etc. backed you up whether you got it or not. They abolished that, right? And gave it, they said the law gives you it, right? Whether you're actually doing it or not. But now they're trying to say that, oh, well, like, if the Parliamentary Commissioner for Standards doesn't take it on, then you must not be doing it. You're not doing that, right? It's almost like saying, oh, let's go to the sports centre, right? Oh, they didn't let you in, they turned you away. So we weren't really going to the sports centre, that type of thing, right? Which is completely and totally, they're trying to make out that there are no many civil processes that exist outside of Parliament, right? So therefore, and they're trying to make out that there can't be any possible contempt of it. Now, this is one thing with YouTube and the platforms. YouTube has got a video saying it's illegal to interfere in electoral processes, right? They've got a special YouTube video that says it's illegal to interfere with or disrupt electoral processes. Now, there are special laws for that the police can act on, right? Because, it's not under the jurisdiction of Parliament anymore, right? Because if you challenge an election, it was all under the parliamentary jurisdiction and all privilege, because only Parliament could hear it. And you do an election petition to Parliament. But since 1868, when they give it to the courts, right, the courts hear it. It's still an election petition, but the courts hear it. And you've got some offences which the police can act on. But you've got to understand, it's still officially meant to be a parliamentary process, and that's why you get sort of like writs of privilege, but they're called certificates of indemnity and things like that in election petitions to courts. And the advertisements for the elections, they're still subject to all these exemptions, like, the Obscene Publications Act exemptions for public good and things like that. Because why? Because they're privileged, like in the Control of Advertisements 2007, right? You've got Class E and F, which is like election processes, and also your petitions to Parliament. We can use any act, right? It's still exempt and protected, except for these particular offences in the Representation of People Act, which the police can prosecute on. But actually, those offences which the police can prosecute on, it's very special that that they're specially allowed for the police to act on, right? Now, the police can't challenge the election itself, right? Let's get this right. The police themselves can't challenge the election like in the normal courts. It's to challenge the outcome of the election, right? You still got to have an election petition, okay? Now, this is the thing. So what's the equivalent of the usage of Parliament, using a process and procedure of Parliament, right, which is privileged, and they don't have the Representation of the People Act for petitioning Parliament, so you don't have any of these unique offences for it. Most of it's accounted for in the common law, like in the control of advertisements and so forth. No court can hear contempt of Parliament proceedings, right? They're not allowed to hear them. So you're not going to have any cases in the courts. And the court theoretically would be in contempt. It would be an issue for the Attorney General's office, but you've got to understand this, right? Currently, the Attorney General's office is only acting in normal contempt of court cases, right? Now, when you're using Parliament, the usage of Parliament, as per in Erskine May, right, the right to petition, causes and matters to Parliament, and that includes if a parliamentary committee asks people for evidence, calls for evidence, right? You know, a parliamentary committee investigation when they call for evidence from the public, or when you are putting a complaint to your MP and he takes your case on, you know, not, you know, asking your MP if he wants to go out for lunch or whatever, right? You know, when he takes your case on, right, or you've got a right to have a casework with him, constitutional casework, right, constituency casework, right, it's matters and causes to Parliament, right? Now, if there's contempt of those proceedings, it's going to be heard by Parliament. Now, this video is 21 minutes long so far, right? Now, if only Parliament, either house, can hear contempt of Parliament proceedings, right? Now, this is when we're getting into the Attorney General business, right? The Attorney General would act if it's a contempt of Parliament, either house, right? Whether it's House of Commons or the House of Lords, he can sit in the House of Lords and be their assistant, right? Now, this is the thing. They're not having an Attorney General. They don't want an Attorney General in the House of Commons. And as in the House of Lords, you know, when it comes to legislation and acts, it's not meant to be like the Attorney General, right? Really, because it's meant to be the Law Lords, right? Or some of them, or at least two of them left now, right? I'm pretty sure it can be two of them. I'm quite sure that it's looking like it can be the Chief Justice and the President of the Supreme Court, right? But I might be wrong about that. But that's when it comes to acts of law, bills and legislation and acts of law going through Parliament, right? But when it comes to contempt proceedings in Parliament, right, it's going to be the Attorney General in a legal capacity. And what if it's the House of Commons? Well, if it's the House of Commons, how can he take part in the deliberations on that if he's a member of the Lords? He's not allowed to because he's not a member of the House. Now, that's where Standing Order 87 would come in, right? So, we've got issues, but so what? They're not. So, there's two important things to learn from this. The first one is this. There currently are hardly any proceedings in the House of Commons when it comes to legal proceedings, right? Like there used to be contempt, right? They're trying to eradicate them and get rid of them. And they're also trying to make it look and sound like, with all these protests, they're treating us as if we're a mob, a gang, or youths just assembling on the street, or like someone kicking off at a football match randomly, or loads of farmers getting annoyed with people parking their cars out of Alton Towers and having a protest. They're trying to sell and frame the position that there is no such thing that the public can participate in as proceedings to Parliament that are privileged, and illegal actions by the police, courts and CPS against those would be a contempt, and it would have to be heard in Parliament, and you need the Attorney General, right? They're trying to make out that there's no such thing that exists unless, for some extremely rare reason, like, you know, the Department of, like, the Procedure Committee might call for evidence and you submit it, and then, I don't know, fucking someone nicks it from the postman, or, you know, I don't know, because, you know, now that we're emailing it all, apparently, you know, you're not walking around with it, you know, in public, so no one would steal it off you or whatever, right, you know? So, apparently only members of Parliament and only people on committees in the whole country are privileged, right? And no one outside of the fucking building, right? Which is not the case, right? But they're trying to make out that it is. And they're definitely not holding any proceedings for it. Now, this is why the Crown Prosecution Service are never going to get any legal action against them or any deterrent to stop doing illegal prosecutions. And neither are the police, because nobody's acting against the police. It can only be the contempt proceedings can't be heard in the courts. So you're not going to get any contempt proceedings. Are the courts doing petition of leave of court ever? No, right? So no one's ever going to prosecute the police, and no one's ever going to prosecute the CPS, and no one's ever going to prosecute the courts for contempt of Parliament, because they're not having any proceedings for it. They aren't doing any. And this is why Keir Starmer himself is such a pivotal character. He was leading the CPS, and now he's leading the whole country. And he is bloody blatantly acting. Keir Starmer is like a barrier to all. He's the defendant shield and champion, right? Keir Starmer is the ultimate champion of all police chiefs, all directors of public prosecution, chief crown prosecutors, and all judges, right? He is the gatekeeper now of the entire Ministry of Justice, the Home Office, the police, the CPS, the lot, because he is protecting them, because the only way we can get them prosecuted for contempt is in Parliament. And he's pretending that it doesn't exist. There's no such process that exists in this country. And apparently, if you've got a grievance over it in Parliament, it doesn't take priority over all of a business, because the Speaker is the gatekeeper of it all now, unless the Speaker says, yeah, before 1977, the Speaker never had such a privilege, right? And apparently that only goes for MPs in their privilege and not members of the public, because they don't need their grievances signed by MPs, right? So the hot spot is on the Speaker as well. But how do you get justice against Keir Starmer? How do you get justice against the Speaker of Parliament? Well, if it's a genuine complaint and not frivolous, and believe me, contempt issues and treasons are not frivolous matters, I can tell you that for sure, right? Particularly if you're very serious about it, right? They're not letting us publish the e-petitions. They're not letting us... It says that we can have the right to air the grievance and collect the signatures through the observation of due process of act of law and the 1688 Bill of Rights. And e-petitions are obstructing and blocking that, not even by standing orders, just by a policy signed by 2 MPs, right? How do you get those MPs dealt with, right? Now, e-petitions is for allegations in public petitions, and it is definitely not there just for amending and strengthening the laws, that's for sure. But they've tried to scrap the existence of public petitions for grievances against MPs and members, and they've tried to scrap it for misconduct with departments, because they've created these ombudsman and parliamentary commissioner of standards. Neither are elected by the people, right? The Parliamentary Commissioner for Standards himself is not elected. So they've managed to conjure up this office and department. He's got assistants and staff as well that aren't elected. The Parliament MPs get to appoint them themselves. They're little buddies, ombudsman buddies, buds, best buddy, Labour Tory, best buddy, buddy, right? Right, oh, it's my buddy, it's my pal, it's my choice. It's like a choice mushroom. Keir Starmer's choice mushroom, right? Not the people's choice mushroom. Oh, let me choose someone now. Not the people want. Like, who's on my side? Who's going to let the police choose a champion, right? Who's going to protect the whole police force, CPS and courts from facing contempt charges? Who's their champion going to be, right? This is the thing. Now, the Ombudsman is now the processes for all the ombudsman, since they've implemented these policies, right, it's like trying to kick a ball in the goalkeeper and someone trying to keep it out. And then the Parliamentary Commission, the House of Commons Commissioner for Standards, right, if he doesn't take it on, no one elected him to do anything. No one elected that man to be anything or anywhere, right? He is he's a political party. He's a Labour Conservative choice mushroom, right? Planted, right? He's a Labour Conservative. He's their champion. He's not the people's champion. Oh, but he's been given a CB and OB knighthood by the king. Oh, he's a king's champion, right? This is almost like the clerks of Parliament. What's the point in having elected MPs? We might as well just have the king appoint the entire Parliament and the king appoint the entire House of Lords and the king appoint everyone, right? You know, are these people are these people elected by the people or what? So, I mean, the Ombudsman defies the point of being elected. Now, your MP's got to sign it off, but once your MP signs it off, they're not voting on it on committees of elected people and so forth. They're not held to account by the public. You know, they're trying to delegate all this very important, serious work, which has got our powers are attached to that usage, right? They're trying to pass it off to non-elected bodies and non-elected departments, effectively like the Department of Transport and the Department of Culture, Media and Sport. Those departments aren't elected, right? No, civil servants aren't elected, right? And all the processes that have our powers to hold to account people, they're not. It's not a judicial power by elected people anymore. And then this is the problem, and they're also wanting to get rid of the juries as well. So they're transformed. It's a miracle that you still vote for your MPs, right? And the fact that the main two parties have got a monopoly over the MPs, that are either all going to be Conservative or all going to be Labour. The government is literally owned by the Labour Party and owned by the Conservative Party, right? As long as they're safely in position, they get to dictate and pick and choose, right? We're at the whole country's being held to ransom by these major parties, right, who are getting to put these ridiculous policies in place. And even the Lib Dems as well, like Jamie Stone, right, which is scandalous. And then you might say, well, but they're creating more and more mayor roles. Yes, because they're safe seats. They're creating these mayor roles because they've got either the Tories or the Labour Party are guaranteed to get a mayor, and then that political party's got control over their mayor, right? If it was independents and they weren't guaranteed to have either a Tory or a Labour mayor, they wouldn't be doing it, because then it would be a gamble. But they're guaranteed that it's ever going to be red or blue, right? Labour or Tory. And even then, Starmer's calling off the elections because Labour's not guaranteed to do it, so he don't want to play. If he hasn't already won, like where his oracle saying, oh, like, you know, go to the fortune teller, right? Or, you know, he's guaranteed that Labour are going to win, right? You know, if he hasn't already if he can't predict that he's already going to win, right, before, he doesn't want to have a competition, which means that he doesn't want to have a contest, right? But yet, Starmer's showing up with his England shirt on, right, standing in front of the stadium while they're all dissing him, saying, oh, yeah, I'm for England, right? No, he's not. He's for Labour. He's a shirt swapper, right? Now, you might say, well, what about the Senedd, right? What about the Senedd? Why have they created the Senedd and they want more Senedd members? They want more elected positions. Well, they're only wanting more Senedd members and more elected positions because, these main parties are dominating and they're guaranteed to win. And they want more power in local areas, right? And they're only doing that because they've already managed to scrap all our power of usage of Parliament and all our privileges of usage of Parliament and all our effect in legal proceedings to call people out in Parliament, right? The Ombudsman and the House of Commons Commissioner of Standards are effectively, goalkeepers, and they're all choice mushrooms, right? They're not elected, and they're effectively working for the civil servants, and they're all, pretty much the majority part of government that's not elected. They're scrapping Parliament. They're actually scrapping Parliament, but they're getting more and more noticed that the Senedd, they're blocking petitions and they're not even making out that it's even properly privileged, and then they're saying they can't hear this or that matter. The Senedd's pretty much pointless and useless. In fact, it's an absolute waste of money. It's a huge middleman, red herring, complete and utter waste of public finances and money, and it's just scrapping the voters, and it's just confusing matters and allowing them to what's happening is there's meant to be law in this country. There's meant to be regulations and legislation. If Parliament's already breaking the law and breaking the rules and confusing people and massacring it, right, which they are doing. Tony Blair has done that in multiple things, like putting judges against their oaths and this whole thing with the Attorney General, and then, like making it very blurred about our privileges or even non-existent about them, blocking petitions through the Petitions Committee. They've completely and totally obstructed us. And then what they'll do is they've got the Senate in more and more MPs who are doing things that they're not supposed to and not understand the law properly, massacre it even more. And they're going to get to a position where they're integrating social media and requiring digital ID more and more. They're aiming for this YouTube government, which is like any reason or no reason, right? They want the government to be like a YouTube policy where they've got everyone joined and signed up and, with their money accounts on there, and they can actually see everything everyone's doing and have access to everyone's information. And then they can just call anything out themselves as they want. Oh, you broke the policy. But the policy's so fucking vague, like, oh yeah, if we don't like it, then you can't have it, right? That's how they want the law of England to be. And this is what they want in a restaurant. I'm Keir Starmer in a restaurant. If you're not, this is the thing about the whole restaurant things. If you're not Keir Starmer, who is like the most hated person in England, you're not going to have someone dissing you in a restaurant, right? You won't be recognised. They want the best. They want, like, the natural order of humankind is that, if you piss people off, right, you got to answer for that. They want to break the normal order of, like, action and reaction, response. They want to change emotions in humans so effectively, right? They can repeatedly slap you around the face, metaphorically, and you're not expected to be angry about that. It's like Khan, right? Sadiq Khan, right, has put all these ULAS charges in, and everyone's furious about it. But because he's the mayor, he can do that. Sadiq Khan can do that. He can piss everyone in London off, right? But because he's allowed to do that, he's got the privilege to do that. And if anyone's angry about it, they're criminal, right? And they're not apparently allowed to, be privileged to retaliate, right? So it effectively just means that, these people can do what they want. Now, this is the thing. It's not. Look, this ties in really to my philosophy over celebrities. I've never liked celebrities, right? Now, celebrities have got this, they get fans and followers, and then they get the fans in the audience, and they're all, like, literally worshipping them, right? No one needs that many people no one needs that many. They're not friends, they're fans, right? Fans aren't friends, right? If fans were friends, then the person, the pedestal person, right, would be friends with all those people, but they're not. They're not friends with them all. If you try contacting Russell Brand, oh, he's my friend, right? Can you help me out? Could you say this for me, Russell? Could you try help us out with that? Speak to them because the face ain't fucking listening, right? They're not our friends. They're fans, right? If they were friends, right, they would give us personal attention and be interested in us and help us. They want us to be interested in them, right? But all on the positive, not negative, right? And also the TV shows have been managing to filter out all the one thing that they don't discuss on Jeremy Vine or on Loose Women or on these TV shows is the harm and damage that their shows and their fame and popularity are doing on the average person or poor person, right? All the phone-ins are only, the phone-ins of the fans, right? So they're ignoring and completely blocking out the existence of all the negative things in life, right? Which that naturally creates. And they're trying to, it's like the dark side of the moon. They only want to focus on the light side of the moon, and they're trying to make out that, the sun shines out of their arse, that it's all sunshine and all positive, right? And the repercussions of social media now is that, it's not all happy. It's not all fans. It's not all positive. There's a lot of negative things, and all these people are very, very angry, right? And the Prime Minister wants, to block all that out like it doesn't exist. So that's why he's saying you're not allowed to say what you want in restaurants, right? What these people want to do, right, is that they want to they want the glory of God in heaven, right? These people want the glory of God and heaven, right? That, whatever they do, it's all good. It's like the Privy Council oath of the king. The king can do no wrong, right? Keir Starmer and Sadiq Khan, right? They want literally to glow like the fucking angels, right? They can do no wrong. Nothing they can do is bad or wrong. And no one in any restaurant or pub or anything walking around, they want them to fucking melt or evaporate away, right? I will walk in the shadow valley of, shadows, but fear no evil. They don't want their opponents to exist, right? And they want everyone to worship them like a fucking sun god, right? And this is what they're encouraging on YouTube and Facebook, and this is what Mark Zuckerberg's all about, right? And Sergey Brin. They want the world, and Neil Mohan, right? They want the world to worship them and be their fans, but fans, not friends. Let's not get too close, right? And definitely not critical friends who have got any criticism or disagreement with them, right? And this is the problem with these people, and they don't like it. And this is the whole problem with the government. They're trying to censor out everyone who's opposed to them, right? And it's turning out that quite a lot of people are opposed to them. And actually, they're actually taking all our powers away from us to hold them to account, which we've got. And they're pretending that those powers don't exist. And this is when it comes down to these things like, the Attorney General and the Parliamentary Ombudsman and the Commissioner for Standards. They've made those processes now so difficult. Your MP's got to sign it off, then the website's not working properly, or we can't accept this complaint because of this little thing's wrong with it, or that little thing's wrong with it. Yet, it's a very serious and important matter, it's definitely not frivolous, and then the fucking records disappear or whatever, whatever. They don't want to resolve problems. This is the thing. And surely there's got to be that many complaints on the police records now that if the police, right, and I know that you can get these things through freedom of information, right, and through particular applications for information, right, but I'm certain, right, if the public were if there was a website, right, with all the police complaints just immediately on there, right, and you could, like, search and filter them, right, with, like, keywords, you know, like on search, like, you know, like on like searching on the library, right? If you could have instant access to all the police force's complaints online and search, filter them, right, and have all of the information, right, so it was there, how many complaints against this officer or that officer, or what were the complaints being done wrong about the police, like, you know, prosecuting protesters or whatever, the public would have a heart attack, right? They would have a heart attack. There's already enough complaints against the police to shut the police down permanently, right? To have them prescribed as a terrorist group, and the Crown Prosecution Service as well, and the courts, right? The Judicial Office Complaints Department, I can guarantee you, right, that if we force them, and this is not freedom of information, I'm saying, like, you know, put the fucking database up now, make it available now on fucking search for all of these institutions, right? If the public had access to see those complaints, right, the government would be prescribed as a terrorist organisation immediately, right? But then they'd be saying, oh no, it's legal privilege, right? You know, this is the thing, but where's ours? You know, where's ours? We need to get these political parties out of this government, because they've been implementing these policies which are actually illegal. They are illegal policies in the e-petitions. They are illegal policies, and they're not law. They're not standing orders. They're not the rules. They're political parties who have implanted these. It's not law. They're effectively issuing. They're making their own set of rules up to staff. Don't do this, don't do that. You know, fucking hell, if the public complain that we're completely, totally incorrupt, make sure you don't fucking do anything about it, right? Or our party's fucked, right? This is what's going on, and it needs to stop, right? And, you know, the newspapers and the government lying about it's a hung parliament, oh no, you've got to vote for parties. Who would say that? The only people who would lie to you and con you about, oh, you know, you have to vote for Labour or Conservative because there's no other option, right? Only the Conservative Party and the Labour Party and the Lib Dems would ever come out with such a claim. Oh yeah, well, if you don't vote for our big major parties, you know, it's a wasted vote, you can't vote at all. What utter tosh! The biggest fib ever that the newspapers and BBC, whatever, could come out with is, oh, you've got to vote for one of the main parties. Surely that's election propaganda. That is election propaganda. In fact, for the government, right, for the government to claim that, you have to vote for one of the main parties. They're not telling you which one, but to say that it's a wasted vote, or there's no point voting if it's not for Labour or Tory or Lib Dem, right, or any of those major parties, is actually election propaganda, because they're actually effectively saying don't vote for an independent candidate. And if the government are saying that, if the government are deterring you from voting for an independent candidate which you have got a legal right to vote for, that is an election offence and a contempt of Parliament. And this is what YouTube videos are like, oh yeah, you know, affecting electoral processes. In the misconduct against petitioners, it says you cannot deter someone, right, from pursuing their cause, right? Yet the police are doing it all the time. And they're even appearing in videos now arresting people illegally, which is putting people off going to protests. There is an offence for this in elections called police propaganda. It's Section 100 of the Representation of the People Act 1983, and it has been the law for a long time. It's not only the police making representations on behalf of parties, but preventing other people from making representations, right, for parties, like Paul Golding and Britain First, right? I'm not choosing them, but that's a good example of where the police have done election propaganda, right? The same legal principle for Section 100 of the Representation of the People Act 1983 is in Erskine May under the law of Parliament for misconduct against petitioners, deterring or intervening in petition causes or any other causes or matters to Parliament. It's the same thing. It's the identical thing, right? Section 100 of the Representation of the People Act, 1983, police propaganda, the equivalent of that in elections, right, for other parliamentary causes which exist, that is in the misconduct against petitioners, right? It's the same thing. Police affecting and intervening in election advertisements and canvassing, right? It's a contempt of Parliament. There are no proceedings being held for this currently. There aren't any cases being heard. There are no cases against the police. There are no cases against the CPS. There are no cases against the courts. Why? Right? Where's the Attorney General in the House of Commons? Right? We don't have one. He's a peer. Right? Now, on the Attorney General's website, he's got contempt of court. Right? But they're using that for contempt of court in court proceedings to have it heard in a court by the Attorney General. They're not doing it like, oh, the court didn't get petition for leave of court to hear a Parliament case, so they're in contempt of Parliament, and it has to be heard by Parliament, right, not the courts. So the Attorney General, besides contempt of court, he's got a list. Look, here we are, look, right, we've got a list of things down here, right? I've just remembered I've got this page open now, and I'm on 50 minutes, so... Look, here we go, right? Look, this is the Attorney General office in contact, right? Now here, we've got refer a Crown Court sentence. So this is the Attorney General office and his modern functions as the office of the Attorney General of England and Wales. He's got an office, right, outside the House of Parliament, right? The Houses of Parliament. And he can deal with, if you want, refer a Crown Court sentence, or nominations of counsel, report contempt of court. Now but it's not report contempt of Parliament. But a court can be in contempt of Parliament by hearing cases without permission for leave of court, which you'll find that is hot on the money for all of these Palestine Action signs and banners, which people are getting arrested for holding. And all of the Extinction Rebellion cases, Roger Hallam, Insulate Britain, all these cases, right, when they didn't get permission of leave of court to hear the parliamentary cause. Because those matters were activities that were being done in pursuance of that. Advertising, canvassing and promoting those causes. Even Roger Hallam over a motorway, when it's only a public nuisance, is a misdemeanor, right? And that's meant to be protected by privilege, right? Misdemeanors, right? So that's contempt of causes and matters to Parliament, right? Freedom of information. So this is actually here. That should really include contempt of Parliament, but I'm not sure whether if the courts are in contempt of Parliament, right, or if you're in contempt of the court, right, but what about when the courts are in contempt of Parliament and it can only be heard in the Parliament? Well, the Attorney General is having contempt of court cases. He's not hearing them in Parliament, is he, right? He's hearing them in the courts. But contempt of Parliament can apparently only be heard in Parliament, right? But they're not having any cases. Well, apparently Culture, Media and Sport Committee are. Well, I would say that if you're canvassing something and it's going to be in the newspapers, right, or on a website or something like that, it's media, isn't it? It's digital media. If it's on a website or something like that, or on YouTube or Facebook, there should be contempt proceedings for the Culture, Media and Sport, right? But I don't see, 50 MPs writing to YouTube or 50 MPs writing to the newspapers to say, why are you charging people VAT illegally on their petition advertisements, They're a small political body. They're exempt. They don't have to be a large body, and they don't have to register with government. In fact, you don't register VAT with government for public petitions unless you're carrying them on for multiple years and you've got a very large turnover and you become something like Big Brother Watch or something like that. Not if you're just doing it one case at a time, but you don't have to pay for VAT to advertise them in the newspaper, that's for sure, right? In fact, now that I've found the old standing orders of Parliament, it's all about newspaper adverts. For private bills, right, it's all about it has to be put in the newspaper, right? But that would have been the case for public petitions once you got the consent through the 1661 Tumultuous Petitioning Act. You would have got a court order and that would get you in the newspapers, and if the newspaper charged you VAT illegally, you would likely go back to the court and say, hey, well, the newspaper charged me VAT on my advert for this petition that you authorised, and you could probably get contempt of court for that. That probably could be a contempt of court, because you got a court order for that issue to go in. It would be like getting a witness appeal. If you went into court, right, and you said to the judge, I want to do a witness appeal in the newspaper, right, and then you got charged illegally by the newspaper for that, you could probably get them on contempt of court for that. I'm quite sure that if you're in a Crown Court, right, and you want to do a witness appeal, and your solicitor says to the judge in a Crown Court, right, we're doing a witness appeal in the newspaper, right, and let's say, like, the fucking newspaper won't have it in there, and then so you get the court to make an order to have it in there, like in those private bills going in the newspaper, right, I'm quite sure that if they charge, like, maybe you would get charged VAT for a court, for a normal court, but not for Parliament. I know that if the newspaper refused to publish it and it was a witness appeal for a Crown Court case, let's say that, like, I don't know if you would, you might have to pay VAT for that, right? But you might be able, if you win the case, you probably claim that money back anyway if you can claim costs, right? You could probably claim that back through the court for costs, the whole monies, regardless of if you pay VAT or not. But if the newspaper won't publish it, right, you could get them on contempt of court for that. That's absolutely for sure certain. If the newspaper will not publish your witness appeal, you can get them on, I think you can get them on contempt of court for that. But for Parliament, under the 1661 Tumultuous Petitioning Act, if you got a consent from a court, and you put it in the newspaper and they refuse to publish it, firstly, it would be contempt. Secondly, because they've made an order that you are petitioning Parliament, that actually puts you under Group 9, Schedule 9, right? Schedule 9, Group 9 in the VAT 1994 Act, right? That puts you under exemption because you're a political body, right? And you don't have to pay VAT. So I'm quite sure that if they still had the 1661 Tumultuous Petitioning Act in place, right, you could get that court to enforce that advertisement in the newspaper. And if they refused it, firstly, it would be contempt of court. Secondly, the VAT would be illegal, right? And you could get help from the court with that because it was their order. Now that you don't have to get the court order at all, you're just doing it directly with Parliament, right? You could, if they charge you VAT illegally, that's contempt of Parliament, right? But like I said, we're not getting any proceedings in Parliament. They aren't doing any. Now, newspapers is media, right? And so is Facebook and YouTube. And this is Lisa Nandy MP that we're talking about, right? I've already complained to them multiple times. We've even had Jim Harver has been replaced since as well, right? Arguments over this, right? The Digital Culture and Media Sport Committee aren't having any contempt proceedings. They had that Nicola Brooks, or whatever she's called, that ginger woman from the newspaper, and they had them up in front of the government when they did all those scandals, right? But they're not having them up in front of the government for charging us VAT illegally. And that Department of Culture, Media and Sport can have proceedings for this at the moment. They're letting us down. Now, what we need is, we need those 50 MPs who have come together with Jeremy Corbyn, right, on those, like, release the prisoners issue. We need, like, those 50 MPs to write a letter to the London Evening Standard and the Sun and Daily Mail, or to all major newspapers, right? It needs to be addressed to all major tabloid newspapers, right? Why are you charging people VAT for small political body non-profits, right? For advertisements in the newspaper. That's what we need, because otherwise... And now's the time when we need to put those adverts. People need to afford those adverts, and it should be accessible, affordably accessible, without the charges on which we don't have to pay. And why are YouTube removing our videos, and why are YouTube in contempt, right? Parliament aren't having any contempt proceedings at the moment, and they need to. And, you know, if the Attorney General is in place unlawfully, how can he be doing anything? How can we trust him to do anything legally or lawfully? How can the Attorney General be trusted to do anything lawfully if he himself is not in position? Now, this comes down to Standing Order number, 87, being a member of the House, but he's not, right? So how can he take part in deliberations or proceedings on committees for digital media and sport if he's not a member of the House of Commons? You know, are they going to have them on the House of Lords only? Right? You know, proceedings. It's not going to be a committee proceeding. Is it going to be? You know, is it going to only be a House of Lords? A House of Lords hearing. You know, but they don't even have House of Lords hearings now. So, you know, but I would suggest look at the history books. Right? Did they have members of the peerage as Attorney General? No, they didn't. They didn't have them as Attorney General. They did not. They just did not do it, except Geoffrey Palmer. But he wasn't elected. He was elected by the people, right? At one point, I'm sure. If you check it, if I'm wrong on that, fair enough. But it appears that he was made a peer straight after he got put into the Commons, right? So, you know, if Standing Order 87, being a member of the House, he can take part in committees, but if he's not, he can't. What use is he, right? It would suggest that he does have to be a member of the House. And it would suggest that, from what I've read in the Standing Orders Committee, it suggests that he can appear in the Lords as an assistant, right? And if he doesn't appear as an assistant, he's meant to be an assistant to a full assembly. You know, if there could be and was, if there were a full assembly of Lords, right? If there was to be a full assembly of Lords, and if he was to be their assistant, then he would not be one of them, would he? Right? Because there would be an empty seat. It would be a full assembly of Lords minus HERMER not being in position, because he's busy assisting them as the Attorney General. So it would be like minus one member, right, in their position, right? So it does not make sense to me or add up at all what they're doing. And, you know, I think Tony Blair is an anarchist. I think Tony Blair... He's well spoken. He's got an extensive vocabulary. Oh, I'm very excited to, he's like a rampant rabbit, isn't he? He's like, he's always very excited. You know, he's very excited, to, act for the greater good of humanity. Even throw some more words in there. I'm extremely excited to act vehemently for the eccentric greater, the immensely greater good of all honourable humanity. How many extra words do you want to put in there? It's like Russell Brand, isn't it? You know, how many extra words can you put in a sentence that don't really matter, that don't actually really affect the sentence, make it far too complicated than it needs to be, right? How many words can Tony Blair fit into the dictionary extra, right, that don't actually matter, right? Like some kind of rampant fucking vocabulary rabbit. But what he's actually doing is he's like Alan Bastard, the New Statesman. He's kind of like the product of the Sex Pistols and John Lynham mixed with Rick Mail and the New Statesman manifested into this rampant rabbit man who's highly excited about everything. Oh, I'm very excited about this paperclip on the table. I'm showing great enthusiasm for the greater humanity of this paperclip on the table, right? But he's set the law of the country against the judicial oath, right? If he wanted to create in law favours for justice, right, if you do us a favour by confessing, we'll reduce the sentence for you, right? Why didn't he change the judicial oath to be compliant with that law? So therefore the justices, could do favours for people for justice anymore, right? Why didn't he make it compatible? Instead, he's set the law against the oath, right? Because that is, what they're doing. They're doing people a favour by reducing their sentence if they confess, right? So, but he's doing the same with the Attorney General, The Attorney General is going to take part in deliberations in the House of Commons, and then the law gets passed over to the Lords, right? And then the Lords deal with it. And if HERMER is not taking part in deliberations in committees, then don't Labour want an Attorney General anymore, right? Why don't Labour want an Attorney General in the House of Commons? So it seems ridiculous. It all seems that, there's definitely something not right about it all. And we're being let down by these MPs, we need the MPs, these 50 MPs have written this letter about those prisoners, right? There's some very serious, important issues that needed sorting out, 2013, 2019. We're now at 2026, right? If these MPs don't get the main newspapers to start taking the tax off, and if they don't get the platforms to stop taking down protected channels that are using parliamentary democratic processes, right? I won't mind, but YouTube have got an actual video saying, no, you're not allowed to disrupt, electoral processes, right? They're not taking down any political party content, but they won't categorise and recognise any of our channels, right? So, I really don't know what they're playing at and how much longer they're going to take with it. And you might say, well, there's so many channels out there now that it's not important. Well, I think it is, because you've got people like Claire Dyer, right, who are now, they've got big channels. They've got channels with 80,000, 100,000 people. They themselves, as persons, have got nearly as many followers as the biggest Facebook groups had, 80, 100,000, 250,000 people following their channels. And they're still now saying, oh, no, we haven't got enough people following us. There's not enough people to make a difference. We're going to have to now start doing more things like go back to basics. We're going to have to put signs up in town centres. We need to put banners up around town centres, in town centres. We're going to have to use the control of advertisements 2007, right? And that means that surely the newspapers should be made use of, to make things official on the record, official petitions, official causes and matters to Parliament advertising in the newspapers, and we shouldn't be paying VAT on that. A lot of these campaigns are getting money thrown at them. They're getting they've got fundraisers, GoFundMes, right? All that is meant to be tax-free. It's not for profit. All that could be paying for newspaper adverts and going towards, boosting the posts on the platforms, but also paying for and making for signs and banners, which should be getting VAT taken off in part of the town centres, and they should be able to get more of them to get more support behind them, right? And it's important that these channels also are protected and don't get taken down as well at the same time. All these issues need sorting out now. They needed sorting out not last year, not in 2020, not in 2015, not in 2013. They need sorting out immediately now, right? Without any further delay, because it's contempt of Parliament. We're being deterred and obstructed from mesny civil process, matters and causes to Parliament, which is, the canvassing, canvassing is something which falls under the parliamentary law of agency. Fact, right? So, now, on this matter of Attorney General, can he get away with saying, I don't have to be a member of Parliament and House of Commons. If I'm not a member of the Commons, I can't deliberate in committees, right? But so what? Big deal. I just won't bother doing it, right? How can he take part in the House of Lords both as a voting member in position, right, and be an assistant on the Woolsack as a separate assistant at the same time, right? He can't, because you've got an empty space. You got an empty space, right? Now that's why you also had the solicitor. You got the Attorney General and Solicitor General, haven't you, as well, in the House of Commons? If the Attorney General's not in the House of Commons, you have the Solicitor General. But I think they were supposed to alternate the proceedings so everything fit in, right? That's a good question. But, what's the final point? Well, we'll read more books in the House of Lords and we'll find out. But, look, let's look at the historical evidence, right? Just look at the Attorney Generals. The question is, right, were they members of the House of Lords? No, they weren't. They weren't members of the House of Lords. It was a one-off anomaly of Geoffrey Palmer because of the Civil War and the restoration of the Crown, and it's looking like he was elected and then immediately put into the Lords or something like that. But why didn't they continue doing that? They just didn't do it. They didn't have them. So, I mean, if you want to say Standing Order 87s, well, if he's not a member of the Commons and he can't take part in deliberations, so what, big deal, right? But, well, where are all these, House of Lords Attorney Generals? Well, there aren't any. They didn't have them. So, why did Tony Blair suddenly think that he could do it? Or why would he need one or want one, right? And why is it only the Labour Party who've done it? Why is it only Blair, Brown and Starmer, right? And why just start doing it? Why just pull it out of nowhere? Why haven't the Tories done it? Why haven't the Conservative Party done it? There's something amiss. There's something not quite right with it. There's something of concern.